Hi, I'm Joe Koury, co-chair of our business law practice group here at O'Donnell, Weiss & Mattei. My colleague.
I'm Gary Stein. I'm the other co-chair of the business practice group.
And we're going to talk to you today about various forms of buying a business. Gary, I don't know about you, but that seems to be a hot topic these days in my practice, the sale or purchase of a business, depending on which side of the transaction you're on.
Yes, it is. And the first question that any buyer or seller would need to deal with is the question of whether it's a purchase of assets or a purchase of stock or LLC membership interest or partnership interest for that matter. But it's basically the purchase of the business as a going concern, including the assumption of debt or other liabilities. That's the main drawback to a purchase of stock or LLC membership interest or partnership interest. And that's why many people will go with an asset purchase, which means the assets are being purchased free and clear of any liens. That would be a requirement of any asset purchase agreement.
Well, let's talk a little bit more in depth about that. And I think we should start with the stock or membership interest purchase, depending on the form of entity. To me, that's the easiest form of buying a business, most clearly understood, particularly because I think to third parties, meaning everyone but the owners or the insiders or the buyers or sellers of the business, there really is no change.
That's correct. The business as a going concern will continue. What changes would be the ownership interest, be it stock, LLC membership interest, partnership interest, and management. At the corporate level, it would often be officers and directors. In the LLC situation, it would be the management structure, and a partnership, oftentimes a general partner. But that's the key. It is, kind of a secret, if you will, that the ownership would change. It wouldn't have to be publicly disclosed. Wouldn't necessarily have to be disclosed to anyone outside of the management and the ownership.
I should add that we're talking here about non-publicly traded companies, what we typically refer to as closely held businesses. Publicly traded companies, that's a whole other realm with SEC filings and the like, but at the level we're talking about, clearly, for all intents and purposes, no one really knows about the change in ownership.
Right. The smaller, closely held business, is oftentimes one or two principals who fill all of those roles. For a corporation, they're shareholders, officers, and directors. So yes, there wouldn't necessarily be any change in other employees or any change in business activities at all. It should be really seamless in terms of any customers or vendors are concerned.
Yeah, I can think of a recent transaction that we had, Gary, where it was a stock purchase, and as a result of that, we didn't have to assist the seller or the buyer with any renegotiation of contracts and the like, because again, the entity just continued on. It was just a change in ownership.
Correct. No assignments of leases, no assignments of contracts, as Joe just mentioned. That's right. And some people that we were dealing with, frankly, had a little difficulty understanding that concept. But that is a primary benefit of a stock purchase. Because if it were an asset purchase, on the other hand, then you would have a transfer of a lease or another contract to the buyer that would require assignment documentation, and oftentimes with leases or other contracts, there's a requirement that the other party consent to the transaction. That can often be difficult depending on the creditworthiness of the buyer and the posture that the other party to the contract would take. So we had none of that in our recent stock purchase, which made it easier on those particular points.
Now, of course, the downside, particularly for a buyer with a stock purchase, and Gary alluded to it earlier, is that you buy the business warts and all, so to speak. So there are liabilities that attach to the stock, which is the ownership of the business, or the membership units, depending on the form of entity. So the buyer, accedes to those liabilities, whatever they may be. They may be tax issues. They may be contractual liabilities. There's any number of possibilities for which a buyer should conduct some due diligence if it's a stock purchase.
Right, and that is a significant risk, and we try to deal with that risk with covenants and provisions in the agreement. We try to have as many possible debts disclosed on schedules, but there's a possibility that some were missed, either intentionally or inadvertently. We deal with representations and warranties. In that particular case, there was a holdback that went into escrow to deal with any claims that surfaced over the course of the year after closing. But, we can't caution highly enough. There's still some risk there. The way to deal with that, and many times people will not even consider a stock purchase because of that debt possibility, is you go with the asset purchase. You buy the assets strictly through the transaction. Any debts or liabilities are left behind with the seller, and that's the way that the transaction attempts to immunize the purchaser from any debts relating to that business.
Yeah, the buyer in the asset purchase context can, in essence, cherry pick the assets or classes of assets that the buyer wants. And typically, in my experience, to further insulate themselves, a buyer in an asset sale will form an entity, his or her or themselves, to actually purchase the assets inside the new entity. Has that been your experience as well?
Yeah, you definitely want a new limited liability entity to purchase the assets, again, to immunize the individual, the person who is purchasing, and would then in turn operate the business. So, you try to immunize the purchaser as many ways as possible, and that's certainly one.
Now, the downside, as Gary alluded to earlier, with an asset purchase is typically contracts have to be renegotiated or consented to assignment. There's a lot more legwork to be done that has to be weighed against the advantages of leaving liabilities behind with the seller that would occur with a stock sale.
Yeah, that is correct. And in a sense, it's a question of balancing the risks. Someone who understands the transaction would make that decision. In the particular case that Joe raised earlier, we had some licensing issues with state agencies, and it was much better to go with the current licenses owned by the corporation, so that there was no delay in terms of ability to take over and run the business. So that was another advantage to the stock purchase.
And relative to the issue of state agencies and the like, oftentimes in an asset sale, assets have to be retitled. You're getting involved with sometimes lenders that have security interests in assets. Again, there's a lot more legwork that needs to be done with the asset sale. In addition, and really beyond the scope of this presentation, but there are very important tax considerations that differ between a stock purchase and an asset purchase. So I don't know about you, Gary, but I routinely involve the client's accountant when we're talking about how to structure a purchase transaction.
Yes, absolutely. For starters, you have allocation issues. How are the assets allocated? And other issues pertaining to goodwill and intangible assets.
Yeah, how the purchase price would be allocated among those assets in an asset sale.
Right.
Yeah. Well, thank you for your time. Gary and I are available to meet your business planning needs, and we look forward to assisting you.